Hey everybody, welcome to Thursday night. I am back. Sorry about last week. We had a week off. It was my son's 21st birthday, and we went on a little overnight trip. But I'm back here on Thursday night, ready to have discussions and go over questions that you may have about how to deal with debt collection lawsuits, bankruptcy, garnishments, all those kind of things that are out there that you're dealing with. Real quick reminder, if this is your first time here, what I do here is we talk about these different topics on how to deal with some of the serious consequences of debt, like lawsuits, bankruptcy, how to deal with them. While I am a licensed attorney in the state of Arizona, I do have to tell you that I can't give legal advice to anybody, particularly those who are not in the state of Arizona, because I don't know the law in your state. I'll always refer you to attorneys in your area that you ought to check with if you have specific questions about your case. And also, by coming on this YouTube channel, doesn't create any type of attorney-client relationship. Periodically, I'll have people who actually reach out, like via email or whatever. I can't answer specific questions like that. Again, I'd refer you to find an attorney in your specific state. With tonight, what I would like to do, I'd like to start off by talking about something that's been in the news lately, and that's this CDC eviction moratorium. There's been a moratorium on evictions throughout this whole COVID-19 pandemic that essentially stopped landlords from evicting people for non-payment of rent and other types of proceedings. And it expired on July 31st. The CDC recently issued an order saying they were extending this through October 3rd. I don't want to get into like the politics of that because it's kind of crazy. Both sides say that the order is likely not constitutional. Regardless, here's what I want to bring up, because I've had a couple people talk to me about this recently, who are renting, and they're bringing up the CDC order as somehow it's preventing the landlord from ever being able to collect rent. And unless you're in the state of California, California forgave a lot of the rent. I think most of the rents during the pandemic. Even if the CDC order stops you from being evicted, they still can try to collect on it once the order expires in October. My opinion is that it's probably going to be thrown out much earlier than that. The CDC, the Supreme Court has said, likely doesn't have the authority that they're alleging they do to go and just, basically freeze the entire rental community throughout the nation. So just take away from that is that you got to be careful. If you're in a rental situation and you're using the CDC order as a way to stay there because you can't afford the rent right now because of job loss or whatever it is, just know that when the order is lifted, that's not going to be a defense for collection unless you're in a state like California that has waived a lot of that. So all right. Hey, right out of the chute here, we have Dave Lamb, who's here each and every week. I appreciate all of you. Same with Marcos. I appreciate you, the support that you give to the channel. They're also members. If you want to join our membership community, that's done there on the YouTube channel, and that'll get you access into our private Facebook group where we talk about these things in a little more detail. All right, let's jump in with Greg first here. All right, Greg says, what if the sale, the value greatly exceeds a homestead exemption in a bankruptcy Chapter 7? Can collections force the sale to make a payment? Okay, so this is a good question, and it's really key to understanding this before you jump into a Chapter 7 bankruptcy. Chapter 7 bankruptcy is great in that it's very effective at eliminating credit card debt, medical bills, those types of debts that don't have any collateral attached to them, any security to them. Like a car loan or a home loan. It's really designed to get rid of those credit cards, medical bills, unsecured debts. They go away completely. There's no payment required. It's a relatively short process. The downside to it is that if you have assets that are not exempt under your state's exemption laws, then a bankruptcy trustee can step in, take the asset, sell it, give the money to your creditors. So that's kind of the trade-off and the give and take on that. So what Greg is saying here, we have a Chapter 7 bankruptcy, and there's a homestead exemption. The homestead exemption protects so much equity. There's usually a dollar amount tied to it. And so what Greg is bringing up, we're seeing a lot, particularly here in Arizona, where the value of the home is over the homestead exemption. And I can tell you that the bankruptcy trustees, they're licking their chops because If your house is significantly over the homestead exemption, if it's worth more, like for example, in Arizona, the homestead exemption protects up to $150,000 of equity until next year. It goes up next year, but right now it's $150,000 in equity. Well, if you file for bankruptcy and you have $250,000 of equity in your home, you're going to be in trouble. They're going to force you to sell the house, pay off your mortgage, give you 150 grand to cover your exemption, and then the rest is going to go to your creditors. Alternatively, what you have to do is convert to a Chapter 13 bankruptcy. So the answer, Greg, to your question is yes, they absolutely can force the sale of the home if you have a lot of equity above the homestead. When people come into my office and they have a ton of equity like that over the homestead, we don't file Chapter 7. We look at different options, either a Chapter 13, debt settlement, fighting the lawsuit, that kind of thing. So hopefully that helps you with your question there. So, all right, I always like hearing like this. Channel, help me answer the demand in Texas. Great. I'm grateful that it can be of help. Grateful that, and I put the link to the tutorials, particularly with the templates and more of a deep dive that we do to the top of this. Check those out if you want to. They can be a big help. All right, let's see. This one might be Virginia specific, but I'm not afraid. We'll dive in. In Virginia, apparently plaintiffs can file a one-time non-suit at any time during a lawsuit for any reason. This happened to me with Midland Funding. I'm guessing MF is. I'm guessing that's what MF is Midland Funding. On the day of trial, would you consider this a victory? So I guess I'm not understanding the procedure. That procedure is different than in Arizona. It sounds like they must have dismissed. If they dismissed and just dropped it, then yes, I would think that's a victory. The question is whether the lawsuit was dismissed with prejudice or without prejudice. A lawsuit that's dismissed without prejudice can be refiled. We see this with debt buyers sometimes if they don't serve people quickly enough, or if they get into a lawsuit and they decide they don't have witnesses, documents, whatever. Sometimes courts will do this if the plaintiff is not prosecuting the case quickly enough. It'll be dismissed without prejudice. You want to have it dismissed with prejudice, because if it's dismissed with prejudice, it can never be refiled again. So that's the important distinction. But anytime they're dismissing, I consider that a victory there. All right, let's see what Audrey has. Audrey says, is an affirmative defense and a counterclaim the same thing? Can you file either one when you file an answer? This is a great question, and it's a question that's misunderstood. So they're not the same thing. So let's talk about affirmative defenses. So in an answer, we discussed this in the course a little bit more. In the answer, you're really starting off by responding to the allegations and the numbered complaints. You know, if there's 6 numbered paragraphs in the complaint or the petition, whatever they call it in your state, the court wants to know, do you admit or deny the allegations that are in each of those numbered paragraphs? Because essentially the court wants to know, do we have a dispute? If you agree on everything, the court will just issue a ruling. If there's a dispute, which there is in debt buyer cases, because almost never are they showing and proving that they own the account in the complaint. They're alleging it, but they're not proving it. So there is a dispute. And then under that, you list your affirmative defenses. Now, a good way to think of affirmative defenses is I like to explain it like in a criminal law context. So in a criminal law context, an affirmative defense would be, let's say that I shot somebody and they charged me with murder. An affirmative defense would be if I said, yeah, I did it, but I did it in self-defense because they were trying to hurt me. And so the way to think of that, so in a criminal context, it's yes, if all the facts are true as alleged by the plaintiff, but you still have a defense. So like a good one in the civil context is the statute of limitations. Basically what you're affirming there is you're saying, look, even if everything that Midland Funding or Portfolio Recovery says is 100% true, I still have a defense. And that defense is that the statute of limitations expired on this debt long ago. And so, you know, there's statute of limitations, there's payment, you know, or partial payment that you've made. And you can list all these the affirmative defenses underneath your different responses to their numbered paragraphs. And it's important to do that. I can tell you from jurisdiction to jurisdiction, state to state, this is a little bit different. In Arizona, often if affirmative defenses are not pled, if they're not provided in the answer, they're waived. So I almost always put statute of limitations in there just to make sure that just in case we get facts down the road, that I need to plead those. So how that differs though from a counterclaim. A counterclaim is where you're saying, and counterclaims generally, there's compulsory counterclaims and permissive counterclaims, and I'm not going to go into all the procedure of that, but generally a counterclaim is if you have some claim against them, against Midland Funding. So let's say Midland Funding files a lawsuit against you, or I always pick on Midland, but let's say it's Portfolio or Unifund or whoever it is. But you feel that you may have a violation of the Fair Debt Collection Practices Act because they were calling you on the phone and threatening to take you to jail over this debt. You could then file in your answer. The answer and the counterclaim are generally done in the same document. So where you respond to their allegations and then you put your claims against them. And then they have to file a response. And that response is usually called a reply, just to make things more complicated than it needs to be. Then they'll file a reply to that, and then the case will move on from there. So that's how they're different. The affirmative defense is just you saying, hey, even if everything they say is accurate, I still have a defense that I'm not liable. Counterclaim is where you have an affirmative claim against them where you feel like they should pay you money because they violated the law or whatever it is that they did. So Audrey, I hope that's helpful there. All right, Ike, thank you. Thank you. Love your channel. Plan to join the Facebook group soon. Awesome. We'd love to have you there. All right, let's take a bankruptcy question with Chad Kane. Chad says, I had my 341 meeting. What's happening in the background and how long does it take for it to discharge? That's a good way to put it because there is stuff going on in the background. This is in the bankruptcy context, about 4 to 6 weeks after any bankruptcy case is filed. There is what's called the meeting of the creditors. Often they'll refer to it as the 341 meeting. 341 is just the bankruptcy code section that authorizes this meeting. This is a meeting with the bankruptcy trustee. They call it the meeting of the creditors. Very rarely do creditors appear. I know that's the number one concern that my clients have. I've been doing this almost 20 years, and I can tell you that I think it's happened 3 times. And it's usually a disgruntled ex-spouse that comes in. Those are the commercial creditors do not appear because the meeting is very quick. It takes about 5 minutes to get through. There's just not a lot of time. And if they have questions, they can contact you or their attorney at a later time to still go over it. So what's happening in the background? So after the meeting of creditors, there's a deadline approximately 45 days after that date that's been set by the court, where if any of your creditors have an objection to their debt being discharged in your bankruptcy, they have to raise an objection to the court. They have to file a formal objection. So everybody's just kind of waiting for that deadline to pass. And again, in 99% of cases, you're not going to have an objection to the debts going away. There has to be a legal, legitimate objection, not just, I don't want my debt to go away, that kind of thing. Also, the bankruptcy trustee, as I'd mentioned in that prior question, is looking at your documents to see if there's any assets that can be liquidated for the benefit of your creditors. Those are the 2 main things that are going on. Is we're waiting for deadlines to pass, and the trustee is looking to see if there is any type of assets that can be liquidated. Assuming that there's not, which in a lot of cases there's not, the trustee will then issue something called a notice of no distribution, saying, hey, I'm not making any distribution in this case. And assuming that you've done your financial management course, which is a little 1 hour or so video you have to watch, the court will discharge your case about 60 to 90 days from that 341 meeting. The discharge order is your order from the judge that says, case is done. Well, I should say that your debts are done, that you're not legally obligated on them anymore. It's a little anticlimactic. It comes in the mail. The attorneys get it the same day you do. It's a 1-page piece of paper that says discharge, and that's the end of it. So that's what's kind of going on there in the background. James, thank you. Let's talk about James here, see what he has to say. I have a judgment from 20 months ago when no collection action has happened. I'm in Arizona. What are the likely reasons that this might have happened? Reasons, I guess the 2 questions there. I guess, are you asking if the reasons that you got the judgment? Probably I'm thinking you're saying because there's no collection action. Surprisingly, particularly with debt collectors, and a lot of this just has to do with the fact that they have such a huge amount of volume that they file and relatively few attorneys, they don't do a whole lot unless they have information that's readily available, like in your credit report, like where you work or you bank. And even then, sometimes the judgment will just sit there. And they'll often record it with the county recorder, and that will act as a lien against real estate in your particular area. In Arizona, that law is in flux right now, because right now a recorded judgment does not act as a lien against your homestead if you own a home, but it does act as a lien against other properties. Starting January 1 of 2022, it will act as a lien. That's Arizona specific. Excuse me. So, but one thing, I don't ever recommend just letting it sit there if you have the ability to either settle it or file bankruptcy on it. Because not that there's ever a good time for a garnishment to appear, but they seem to show up, out of nowhere. Not only that, many debt collection judgments, they bear interest at the contract rate of interest. So usually a credit card goes into default. It's, churning interest at 29%. They file a lawsuit on it, and the court enters a judgment. And then the judgment can earn interest at 29%. And on top of that, there's a statutory 4.5% interest. And so it can cause a lot of problems. All of a sudden, this, relatively, a small judgment. I've seen this all the time where it's like a $3,000 judgment, and then they don't try collecting on it for like 6 years, and all of a sudden then it's like $15,000. So if you have the ability to reach out and try to settle it or file bankruptcy, if you're going to go that route to get rid of it, that's the way to do it. But that's likely why nothing's happening. It's generally not as calculated or sinister as people think. It's more just that they have too many cases, or that they look at your credit report and they don't view it as collectible, so they're just going to sit on it and maybe revisit it a few years down the road. In Arizona, civil judgments are good for 10 years. They can be renewed for every 10 years for the rest of your life. And so it's a good idea not to leave it just sitting out there, because that can cause you some problems. And look at that. He's saying that's exactly what happened. All right. All right, let's see here. Let's see what Morgan has to say. MG Morgan. In Arizona, you have a pretrial conference with Midland Credit Management in the morning. So this is relevant stuff we're dealing with here. They haven't sent proof of debt as mine with an agreement or an application. I had identity theft. I think this is another. Okay, so the pretrial conference in Arizona is kind of often it's kind of a letdown. You're expecting this to kind of be your day in court. A lot of, particularly if it's in justice, well, it is in justice court if it's a pretrial conference. A lot of them now, they're just having the parties contact each other over the phone. And so it may be something where you're just dealing with the attorney for Midland Credit over the phone, and the judge won't even appear. Some of the courts are still having you call into the court or even appear at the court, and you're appearing before the judge. And usually what they're going to ask, have the parties exchanged initial disclosure statements? The fact that you're saying they haven't sent you that, if it's in person, they'll likely give you that tomorrow. The disclosure statement, where they have to provide all their documents and proof, that is due 40 days after the answer is filed, but it's just exchanged between the parties. So sometimes that gets a little bit sloppy on the timing. And if you look at the pretrial conference notice, it'll say on there that by the pretrial conference notice, the parties need to exchange disclosures. So that's what's going to happen. Usually the court will ask you if you guys want to talk settlement. If you're in the courthouse, they'll tell you to go out in the hall and just see if there's any kind of middle ground. And if not, a lot of times they'll either give you a trial date, or they'll continue the pretrial conference and have another one in like 60 days. You'll be able to have some input on it. So that's typically what you're looking at. If it's an identity theft issue, I would bring that up to the lawyer. The debt buyer lawyers, if there's an allegation of identity theft, will often provide you something called an identity theft affidavit that you'll need to fill out, which kind of goes over the facts of the identity theft and provide that to them. And then they'll submit it to their client to see if they'll go ahead and dismiss it. So, all right, let's see here. A couple more. All right, let's go with Tiffany. Does a judgment have to be reported to the court every 6 months for an update or any time frame? And if so, can I get the judgment dismissed? So judgments, again, in Arizona, which does follow something very similar to other states, judgments have to be renewed every 6 years. And so the renewal process in Arizona is that they have to file an affidavit of renewal with the bankruptcy court, and it has, or not the bankruptcy court, with the court that issued the judgment. they file this affidavit of renewal, and it's very specific as to the timing. It has to be no later than 10 years after it was filed. They changed the law, so it's 10 years. And then, but no earlier than 90 days before that expiration of that 10-year period. So that's going to be different from state to state. But you can't, the only way that the judgment will become void is if they blow the deadline. So whatever state you're in, you need to look and see how long civil judgments are good for, and then what the process is for renewal. And then if it comes and goes and they don't renew it timely, then the judgment is void, and you really don't have to do anything at that point because it's just completely done. So, all right. Let's talk about this one. This one caught my eye because someone just came from the endodontist. All right, I need 2 root canals. Let's say I use their credit system. What happens when I file for bankruptcy Chapter 7? Is this something that you do a reaffirmation like a car? This is also a good question because people run into this quite a bit. I often have people come in who are filing for bankruptcy and they say, I don't want to include a certain debt. And a lot of times it's medical. They're like, hey, I don't want to discharge this debt to my doctor because I still have to see the doctor because I have some ongoing medical issue that we're dealing with. So that in cases like that, first of all, you need to know you have to disclose all your debts if you're filing for bankruptcy. You have to disclose them all. Doesn't matter if they're owed to a family member, a credit card, to a doctor, whatever. You've got to disclose all of your debts. And the bankruptcy discharge that you receive states that you are no longer legally obligated to pay anybody back. You don't have to. But certain creditors, that doesn't mean that the creditor has to continue to work with you. Your credit cards are going to be cut off. And if you're working, you're endodontist here, if you file bankruptcy, you don't have to pay them, but they don't ever have to see you again. And so because of that, what's important to remember is that the bankruptcy discharge means you're no longer legally obligated. However, you can voluntarily pay anybody you want back after the bankruptcy is over. Surprisingly, most commercial creditors will not agree to do this. Like if you went to your credit card company and say, hey, I want to pay you, they're not going to do it because they're worried about violating the discharge order that the bankruptcy court entered. But with a doctor, a formal reaffirmation agreement is typically not required. I don't ever do those with my clients just because there's other consequences to that. But a lot of times I'll tell them if there's a doctor they need to work with, they can go and talk to them and say, look, I'll voluntarily work with you on this just because I want to continue to use your services going forward. So that's what I would recommend on something like that. All righty. This is kind of an interesting one. It says, I live in Florida. Can a creditor take my home if I claim as an exemption? I believe, and you can correct me if I'm wrong here, because I don't live in Florida. I don't practice there. I don't know. I believe Florida is similar to, I believe, Texas in that you have unlimited homestead exemption. People often joke that's why O.J. Simpson moved to Florida, is because he had those big civil judgments against him. And you could buy a home in Florida and it's completely exempt regardless of how much it's worth. So if it's an unlimited homestead exemption, I would assume that they couldn't take the property in Florida. I don't know that to be the case 100%, but the exemption does protect up to a certain dollar limit. Like I said, in Arizona, it's 150,000 right now. In certain states, it's unlimited. In other states, it's super small. I can't remember if it was like Tennessee or somewhere that I saw it was like $15,000. I was surprised at how low it is. But that's the purpose of the exemption, is to protect it. So, all righty. Here's one. It says, if the creditor renews a judgment, do they have to serve you? Do they have to go to court to renew, or just by filing a motion? Again, I only know the process in Arizona, but it is not something where they serve you again. There's no new lawsuit, no process server. They just file documents with the court and then usually file a copy with the county recorder. There's no other court proceedings. So you're going to have to kind of watch that. It would be my guess in other states as well, but in Arizona for sure, you would have to watch that. So, all righty. Let's see what else we have. Let's see what we have for Irma. I had a hearing for a citation to discover assets. The plaintiff lawyer didn't attend. I was present. The judge said it's a strike for the plaintiff. What happens next? I hope the judge dismissed it, because this is a pet peeve of mine when if the collection attorney shows up And if the defendant doesn't show up, judgment's entered almost immediately. They're up there signing it, walking out, they've got their judgment. I can't tell you how many times I've showed up to court. I'm sitting in there, and I'm the only one in the whole courtroom. The judge comes in, debt collector's attorney is not there, and they'll say something to me like, "Well, let's continue this out 30 days and see where they're at." And I always stand up and say, respectfully, if my client wasn't here, judgment would have been signed a few minutes ago. And the judges have to agree that that's typically what they do. And so I request for it to be dismissed with prejudice, and then I ask for an attorney's fees award against him for not showing up and wasting everybody's time, and that's been pretty effective. So if the judge is just saying, well, that's a strike for the plaintiff's attorney, meaning that they're going to look bad in the future, I would ask for it to be dismissed if they're not there. That's if they're not, if you weren't there, there would be huge consequences. If they're not there, there should be consequences as well. All right, let's do one more. Tiffany, here we go. Do any wage garnishments have to be reported to the courts during the garnishment or after it's paid off to let the courts know the balance or if it's been paid off? So wage garnishment statutes are very specific to the different states. And often they are what I believe to be needlessly complicated. But yes, in most states, there's going to be some type of reporting function, whether it be monthly or quarterly, where they're going to have to provide showing how much they got and how much is still owing on it. That way you'll get a copy of it and you'll know. And then once the garnishment or the judgment has been paid in full through the garnishment, they're required to generally file something called a satisfaction of judgment with the court to show that it's been paid in full. You could also take that satisfaction of judgment and record it with the county recorder to show that it's been taken care of completely. So that's generally what you're looking at for that. All righty. I think that may be the questions for tonight. And we're about 30 minutes in, which is our normal, usual time that we do this here. So last call for any other questions. Otherwise, we'll close it out. I would recommend, like I said, we've been just starting up this new Facebook group. It's a private group. You can join it by clicking on the membership tab on the YouTube channel, and it gives you some instruction there. And again, I just recommend you check out our online tutorials. I put a lot of effort into those, and we have templates in that can really help to get through a lot of these things that you're dealing with. So, all right, we'll do Ryan. Could be the last one. All right, thank you, Ike. I appreciate it. Honestly, I appreciate that. All right, we'll have Ryan be our last one for tonight. Credit card terms define default in multiple terms, one of which is if the balance is above the credit limit. Is there evidence that at one point previously the balance was over the statute? So I think what you're asking here is, okay, when we look at the terms and conditions of a credit card, and they have multiple things like filing a bankruptcy, even if your if you're current on your card, is considered a condition of default, or the card will then be deemed in default. So they're saying if the balance is over the credit limit. What I would double check is if in any of those, it requires the credit card company to reach out and deem it in default. Send you a letter saying, okay, you're over your limit, so now you're in default on that. It could be an argument saying, hey, it's now in default. Because for statute of limitation purposes, it starts clicking. That's what we're trying to look for, is when did the account go into default to start that 3-year or 6-year, however long the statute of limitations is in your particular state. So I think it's a good argument. I would just double check the terms and conditions to make sure that the credit card company doesn't have to do something that would essentially formalize that so that everybody's on the same page. If you're missing payments, obviously that's in default. But like I said, you can argue it. I think it's a good argument, and it's something that they're always going to come in and say charge off is when the statute starts to run. That's garbage. It's much earlier than that. Charge off is 6 months after the payments stop, and so I would go back and just started from there. So, all right, we're going to close it out tonight. Eduardo, thank you as well. Appreciate the super stickers tonight. Appreciate y'all checking in, and we do this every Thursday night, unless it's my kid's birthday, then I miss it. Other than that, I'll be here each Thursday night to answer questions. We also release a new video each and every Tuesday, so check that out. Those can be helpful. But I appreciate you guys all watching tonight.